Gary DeWaal here, and this is Bridging the Week for December 1st to 5th, and today is December 8th, 2014. Good morning. Clearinghouse risk management controls and procedures, as well as potential recovery and resolution, continue to be the subject of much international debate, with one clearinghouse formally weighing in for the first time. In addition, another employee of a proprietary trading firm was indicted for stealing his former employer's secrets, while an international regulator gave the United States a commendable grade for rolling out Basel capital standards for banks. There was a lot going on last week, so let's get started. Invoking the specter of the default of HanMag Securities Corporation on the Korea Exchange last December 2013, without referencing the firm by name, Commissioner Mark Weechin of the Commodity Futures Trading Commission called last week for a dialogue regarding at least 3 proposals to enhance risk management by clearinghouses. These proposals included 1. Enhancing transparency by potentially instituting standardized stress tests, 2. Requiring clearinghouses to maintain skin in the game as part of their default waterfalls, and 3. Barring ultimate client collateral from non-defaulting members from ever being used as part of a clearinghouse's default resolution. Mr. Weechin provided his insight during a speech before the FIA's Asia Derivatives Conference held last week in Singapore. Previously, last December 2013, HanMag, a Korea Exchange clearing member, defaulted on certain obligations to the exchange after entering an error over 36,000 orders involving KOSPI 200 index options. As a result, HanMag sustained trading losses in excess of $43.5 million and failed to pay most of its obligations to the Korea Exchange as a result of the erroneous trades. The Korea Exchange ultimately satisfied HanMag's default from other member deposits in the exchange's joint compensation fund. Mr. Weechin cited Korea Exchange's experience with HanMag as an example of the success of the clearing model. Quote, "Indeed, one could say that the fundamental framework for loss mutualization was tested and proved sufficiently resilient at the Korea Clearinghouse given the fact that losses of the defaulting securities firm were absorbed and trading on the exchange resumed relatively quickly." End of quote. Notwithstanding, because of recent efforts to increase centralized clearing for over-the-counter swaps, Mr. Weechin argued that it was important, quote, "to be cognizant of and effectively address the resulting increased concentration of risk in the cleared space." End of quote. Separately, LCH.Clearnet published a white paper setting forth its perspective on clearinghouse risk management, recovery and resolution, and offered its view on principles that should govern clearinghouse recovery and resolution regimes worldwide. Among other things, the clearinghouse supports efforts to develop, quote, "standardized stress tests of clearinghouse risk management methodologies, and believe that the disclosure of the results could help increase confidence in clearinghouses and identify best practices." End of quote. Argued that recovery tools should be developed in consultation with clearing members and their clients, be agreed upon, and provide, quote-unquote, "certainty and transparency regarding the amount of any contingent liability," and submitted that clearinghouse resolution will be most effective, quote, "if it is led by the resolution authority of the jurisdiction in which the clearinghouse is established." End of quote. However, LCH is opposed to any requirement that clearinghouses contribute substantially more of their own resources, or so-called skin in the game, to a member default, other than the 25% of the clearinghouse's minimum capital requirement as currently required in Europe under the European Market Infrastructure Regulation. By the way, there is no equivalent requirement in the United States. According to LCH, quote, "any requirement for the clearinghouse operator to contribute significant additional resources to the default waterfall and link them to the overall member exposure would fundamentally change the operator's risk profile, creating increased risk exposure to member default at the very time that the operator should be resilient in order to ensure continuity of the clearing service and stability of the market." End of quote. LCH claims that if clearinghouses were required to increase their skin in the game, quote, "it would create an incentive for the clearinghouse to minimize the size of default funds, for example, by increasing initial margin requirements." End of quote. The debate regarding clearinghouse skin in the game and other measures to enhance risk management and controls by clearinghouses has been reaching a crescendo these past few weeks and deserves to be aired formally and publicly, as Commissioner Mark Weechin of the CFTC promises to do at an upcoming meeting of the Commission's Global Markets Advisory Committee. The white paper by LCH evidences that the debate will not be one-sided, and along with Commissioner Weechen's remarks before the FIA's Asia Derivatives Conference, demonstrates why any requirements on clearinghouses must be coordinated globally. David Newman was indicted by a federal grand jury in Chicago for stealing trading strategy computer code for an unnamed Chicago-based high-speed trading firm where he previously worked from July 2004 through March 2014. According to the indictment, Mr. Newman is alleged to have copied computer files of his prior employer on 3 occasions in 2013 and 2014. After leaving his employer this year, claims the indictment, Mr. Newman used NTF LLC, a company he established in 2013, to access the CME Group in order to speculate in futures markets. As recently as 2011, Mr. Newman is alleged to have signed a document with his prior employer acknowledging the confidential and proprietary nature of its computer files. If convicted, Mr. Newman could be sentenced up to 10 years in prison and be required to pay a fine of up to $250 million for each of the 3 counts of theft for which he is charged. UBS Securities was charged in disciplinary actions brought by the Chicago Board of Trade and the New York Mercantile Exchange with violating requirements related to block trades and record keeping. The firm settled these matters by paying an aggregate fine of $120,000. Specifically, on multiple days in 2011 and 2012, UBS was alleged not to have reported block trades within 5 minutes of execution, as required. UBS was also charged with not maintaining required records in connection with multiple block trades in 2011. NERA Economic Consulting issued a report that claims initial and variation margin rules for uncleared swaps recently proposed by the CFTC could result in incremental annual opportunity costs of $411 million under normal market conditions and $871 million in periods of quote-unquote elevated financial market stress. Moreover, says NERA, quote, pro-cyclical aspects of the proposed rule may increase such costs substantially in times of elevated financial market stress, and aspects of the proposed rule that are stricter than international standards may reduce the competitiveness of domestic swap market participants with respect to foreign competitors threatening domestic derivatives-related jobs, end of quote. And finally, the Bank of International Settlements gave the United States a largely compliant overall score in assessing its rollout of the Basel capital framework for banks. The assessment was limited solely to evaluating the quote-unquote consistency and completeness of U.S. regulations compared to Basel's minimum requirements. The BIS found that 11 of 13 components of the U.S. capital framework, quote, comply or largely comply, end of quote, with Basel requirements. 2 areas that were materially non-compliant, but not critical, were the so-called quote-unquote securitization framework and the quote-unquote standardized approach to market risk. I discuss what these terms mean and actually give the surprising grade European regulators received for their rollout of Basel capital rules on the website. Check it out. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. As I said, check it out. Until next week, this is Gary DeWaal. Have a great week and ciao!